case of the people versus Shabab Jackson.
We're ready on that, Maddie. Right?
Laura Willenbring for the people.
Mr. Jackson, could you state your name for the record, please?
Shihab Jackson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter be set for preliminary examination at the earliest possible date.
April 4th, 2023, 9 a.m. before me.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to. Well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And for some reason, it wasn't a drug case or have anything related with drugs. And I'm on the daily reporting thing. And I believe I may have. I think I missed mine yesterday. I don't mean to be in violation, but I'm just sort of struggling with that and confused as to why that is.
Your Honor,
if there's a way to lessen that, or like, I don't see the reason for being on the drug testing.
Having heard what Mr. Jackson has stated, we'd ask that
this hearing turns tense fast.
the
We're not talking about paperwork or
tether
missed
aspect
court dates.
or the
We're
drug
talking
testing
about a
aspect
taser
actually
being deployed,
be reduced
an
in this case,
officer
or
drawing a
dismissed in this
weapon,
case.
and an
As he stated,
injury
there is
serious
no,
enough to require
drug
an
aspect
orthopedic
to
surgeon.
this case whatsoever.
The question
And
before the
this
court
just,
isn't
serves
guilt
as,
or innocence.
an
It's
added
something more
burden on
immediate.
him.
He's
Should
on
this
intermediate
defendant still be
supervision.
free at all? What follows is a sharp clash between facts, interpretations,
I'm not sure
and a
why.
judge who
Well,
refuses
I'll
to
handle it,
accept
Mr. Jackson.
anything
I
but
got you.
direct answers.
As set by the magistrate back in the beginning of March. I'm disinclined to change that at this point. I guess I'm not sure why his testing, why Ramadan would interfere with his testing. I understand that he may have certain obligations, but I have other individuals who are engaged in the celebration of Ramadan who aren't having these issues.
Well, it's not
So-
celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way and pay money that I really don't have and time that I don't have to drug test on this man.
It was Ramadan, and I thought that there was some interference with what he had to do, but I'm not changing it. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
So is it not possible to amend the drug testing, Your Honor? I understand is it just a?
Okay, so hold on.
Yes,
hold
sir.
on. I think I already said that, and I wasn't going to say anything. I will make, Ms. Willenbury, I'll make all the changes that you want. I'm just going to tell you something, sir.
Yes, sir.
What I will do what I can for people. I am also very for those that work around me. I got a message that you were very insulting to my clerks. So
To who?
you ought to be that I'm
Mr.
letting
Jackson,
you.
stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So
Young black
yes, I
man
will.
fighting for
Mr. Jackson,
white
not
attitude.
oh.
I'm listening.
You need to be quiet.
I am making sure I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not.
I'm not trying to. My life is on
Okay,
the line here.
all
That's all. That's all I'm.
Okay, you know what? You know what? Put some deputies at that door right now, right down there at the door. Because he apparently just called security, get him down at that door. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So
You're
don't
not
even
fighting
try
for your
it.
freedom.
Don't
sir. With all
even
due
try
respect.
it. Don't even try it.
Don't even try
Alan,
once,
get
sir.
down there.
Tyree
Get down
Nichols,
there.
14
Get
This
down
is
there.
where bond hearings
black
become
get down there.
dangerous
Take him in.
territory.
Sir,
The
I'm going to
defense
find
is
you in
asking
contempt
for
for interrupting the
flexibility,
court.
remove house
Mr. Brown,
arrest
if you've
so a
got somebody
20-year-old
down here,
defendant can work,
he
attend
can come
online
in, he can
classes,
see me
and
in
move
person. We'll
forward
wait
with
for a
his life.
prosecutor to get
The
down here and I'll deal with
prosecution
this
is
in person.
painting
I'm
a
passing it right
very
now,
different
but
picture.
right now he's being taken
Multiple
in because I'm
assaults,
not dealing with it.
resisting
I'll
officers,
pass
a
this matter.
taser deployment, and an officer
Sir.
injured badly enough to need
Mr. Jackson, if
specialized
you
care.
would just
And then comes the moment
maintain
that
your
shifts
That's called the case of
everything.
the people of
The
the state of
judge
Michigan versus
stops the
Jessica
narrative cold
Lynn
and
Kyle.
asks one simple
Ms.
question.
Ganatra, First
Was
Assistant
the
Prosecuting
taser
Attorney,
deployed?
on behalf
No
of the people.
speeches, no framing,
Zachary
just
Ward on behalf of Ms.
facts.
Teal, Your
Because
Honor.
when
Can we
force is
approach
used
very
by
briefly on this
police,
matter?
every word suddenly carries weight.
You really want to go into a room with me
Your
right
Honor,
now?
Your Honor,
Sure,
I don't
fine.
think-
Yeah,
Your
give
Honor-
us a bench conference.
Your Honor.
Put Mr. Ganatra and Mr. Ward into a room with me.
Next part, the defendant returns to the courtroom later on in the docket and does exactly what all of you have been screaming at your monitors for him to do and shuts up long enough for his attorney to defend him.
Court recalls the case of the people versus Shahab Jackson.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Mr. Jackson, would you state your name for the record, please?
Yep, Jackson.
All right. We're here. I set this already for preliminary examination, and it didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond and having him sit. But I would like to give him an opportunity or have counsel explain to me what's going on with this young man, because the behavior was unacceptable.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and I want to start with that. We did talk about, and I was able to explain to him what contempt is considered in court. We went over that the definition is a willful act, omission, or statement that tends to impair the authority or impede the functioning of the court. In the course of our conversation, I learned that in 2015, so approximately 7 years ago, during Ramadan, Mr. Jackson was incarcerated and his grandmother died, and he was unable to get a pass, go to the services, spend any last few days with her. And so this time frame specifically is very triggering, but definitely with him being involved in court again. He has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity to come into court on his own.
Well, and I'm going to tell you from my standpoint, he kept trying to overtalk me, and that ultimately, and you can tell him, Ms. Gaines, anybody that's been before me, that will never happen. And then, but what was so bad is the person that's trying to help you, Mr. Brown, is trying to get you to be quiet, and you kept talking. And I don't know where you thought you were going to get to, but I can tell you right now, you do that in my court, this is where it leads. I can't tell you necessarily that you're going to listen to your attorney, but you're certainly not going to sit up there and interrupt them. And I'll tell you, I've been doing this for a long time, and when I see somebody that's not listening to their attorney, especially somebody that's esteemed as Mr. Brown, and others telling you what to do, that's a person that's not going to listen to anything. I have to almost believe they're not going to listen to anything I'm telling them to do. Those are the people that end up getting themselves incarcerated. I'm then also
This
very
hearing isn't
disturbed
about
that
sympathy or speculation.
he
It's
got,
about risk. A
you've
young
got
defendant
defense
with
counsel,
no criminal history.
and then you're down at
versus
the prosecutor's
allegations
office.
involving violence,
I don't
resistance,
even know why you're
weapons
down
drawn,
there.
and an injured officer.
Well, you're trying to
judge's
give them something or
frustration is
whatever,
clear.
and you're
Not
trying
because of
to
emotion,
give
but
them something,
because of
haven't told your
unanswered
attorneys that
contradictions.
what you're doing.
Bond decisions aren't rewards. They're
That
trust
doesn't even make any
assessments.
sense.
And in
It's
cases
almost like
like
you
this,
want to get
trust
locked
is
up.
measured in seconds, split-second decisions, and whether the court
I will be honest with you, sir. I looked at the charges and see your previous record. I get what may have happened to you in 2015. I see the timing of it when I'm looking at your record, but then I see what you did afterwards. Whatever your thoughts are, you just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, I'm going to trust Miss Gaines. Miss Gaines tells me that I should give you another chance. And Mr. Brown told me the same thing, that I should give you another chance. These are these people you won't listen to, by the way. But if they tell me to give you another chance, I'll give you another chance. But I'm going to let you know you don't have any other opportunity with me to mess up. You mess up, I'm sending you. Am I understood?
That a yes?
I'm also going to add so I will continue his bond. He can be released to custody. I have the amended complaint. I am going to also add as a condition of his bond to be entered into lien that you are not to go within 500 feet, except if you're going to, well, that's outside of the 500 feet of the Washtenaw County Prosecutor's Office in downtown Ann Arbor. You understand that?
He's indicated yes.
Pardon?
He's indicated yes.
All right, very good. So we're adding that to lien. So I want you to know what that means. If you're within 500 feet of their offices, police officers come on you, they can arrest you on that. So don't say you didn't understand because I explained it to you. Anything further?
No, thank you.
All right, his bond.